Yeah.
All right, good morning, everybody. It's 11:05. I want to respect everybody's time. So if they walk in, a little later. But we have attorney Emanuel Thomas coming around to Long Beach to do a little training on probate. It's been a while since we had a probate class, so it was a good time to have one right before summer starts. So further ado, we'll have attorney Emanuel Thomas.
Good morning, everyone.
Good morning.
I'm going to have my paralegal assistant come up here with me. This is Lucero Malena. She's my right-hand person right here. I couldn't do anything without her. And just a note, she made this slideshow and then told me what I was going to talk about. Now, I've done a lot of work with Norma and with Kareem. In fact, Kareem and I have a few probates going on right now, about 2 or 3, something like that. And we do them on a regular basis. It was ironic how we met. I met his wife first, just a little bit of background. My wife and I were driving. My office is in Bixby Knolls in Long Beach. My office is in Bixby Knolls in Long Beach. My wife and I were driving on a Sunday, and there was an open house. So we went into the open house and met Kareem's wife. Had no idea she was his wife. We hit it off really well. Gave her my card. She gave me her card. And then months later, I'm working a probate, and Kareem is working a probate on the other side, the opposing counsel. And for some reason, Kareem and the opposing counsel didn't get along. So he said, let me talk to Mr. Thomas and see if he can work this out. He goes, oh my God, I love your vibe. You're such a cool guy. I'm gonna see if the seller will switch to you. And sure enough, she met me, switched to me, and me and Kareem been doing business together for what, years now, huh? Yeah, years now. Yeah. So does anyone here understand the probate process? Know what probate is? Go ahead, tell me what is probate.
So I understand that once somebody passes away, whoever is their trustor is, if they have a trust, and the trustee is the one who that kind of takes care of the transaction, or is that?
You're on the right track. Anyone else? I'll try to explain it. Nope. I'll move for it. That's my wife, my lovely wife, Mrs. Uma Thomas. We decided to put her picture on there because she thinks that Kareem and I are just having fun. I want to show her that we're actually working. I'm a sole practitioner in Long Beach. I specialize in criminal defense, personal injury, and probate. I used to be a general practitioner, but I cannot stand family law. People bicker over a dining room table. I just can't stand it. So when you deal with probate, the person you're going to talk to is in my office. You'll be dealing with Miss Lucero Malena. She knows probate like the back of her hand. Absolutely wonderful. Now, to answer your question, to piggyback on what you're saying about probate, probate is actually a judicial process. And when anyone passes away, if there's a court proceeding, it goes through probate. It doesn't matter if you have a will or if you have no will, it goes through probate. Does anyone know what intestate is? What is intestate?
It's when you didn't have anybody in
You the college student, aren't you?
Yeah,
you on it, man. I heard you working for here. You working on your good. You working on your finals. Now intestate and how the process goes. If your husband and wife, the spouse comes first. Second, the children. If there's no spouse and no children, then the parents. If there's no parents, then the nieces, nephews, cousins, uncles, that type of thing. All right. Now, the probate process, if you have a will, you still have to go through probate. But what happens is the judge will make sure that the decedent's wishes are granted. So say, for instance, if I pass away and in my will, I said I'm leaving everything to Lucero, but I don't have a trust, it's still going to go through probate and cost the loved one a lot of money. But in the end, everything will pass through Lucero. Versus if you don't have a will, it'll go through probate, then it'll go intestate. The courts will look for the next of kin, which would be the spouse. If there's no spouse, the children. If there's no children, the parents, and so on and so forth. And that process generally, I don't want to get ahead of myself. And that process generally takes about anywhere from 6 months up to 2 to 3 years, depending. Yeah, we've done it as fast as 3 months. But here's the ticker. In California, it doesn't matter how fast you do it. You cannot close a probate no sooner than 6 months. So Kareem and I did McKinley. I think it closed in 3 months? But we sit there and had to wait. We had to wait till the 6 month mark before they can get paid.
The
Yes.
reason why you have to wait 6 months is because of what?
California law, just like you can't get divorced no
Oh.
sooner than 6 months.
I didn't know that.
Yeah. No. That was an absolute great question. I'm making fun of California. We just have these rules that says you just gotta wait. So we can do it as fast as 3 months. What was fast? Was it 2 months that we did?
Eric
No, not Eric. Stevens.
Yeah, it was like
About 2 months, but we still have to wait. Have to wait to the 6 month point. And then we had some that took about 3 years. And I'll explain it to you. Let's maybe watch this video.
When a family member or friend passes away, it is a difficult and emotional time. In addition to the grieving process, there are usually legal hurdles to jump over in order to settle someone's estate. More often than not, this is accomplished through a process called probate. What is probate? Probate is a legal process that includes the collection and distribution of a decedent's assets. It also involves paying off any debts someone may have had at the time of their death. Probate begins with the filing of a death certificate, followed by the appointment of an executor by the relevant state court. The executor is responsible for gathering the deceased person's assets, paying any outstanding debts to creditors, and ultimately distributing the remaining assets to beneficiaries. If the deceased person had a will, they almost certainly nominated someone to be executor. If they did not have a will, the court will work with interested parties in order to appoint an executor. If you or someone you know has an interest in an estate or has the priority to serve as an executor of an estate, it is important to seek legal guidance to help with the probate process.
Now, when is probate required? We kind of touched on this a little bit before. I want you to think about probate. Change the word probate to public. Change the word trust to private. So when you have a will or you have no will, it's going to be public. The world's going to know. What's going to happen first is we have to publish it. In other words, let the world know that Kareem passed away. Okay, Kareem. Let the world know that someone passed away. And then what generally happens, when I was explaining to you that sometimes it takes up to like 2 to 3 years, because what happens is we found out that Kareem had a child in Louisiana. And then that child in Louisiana hires an attorney in West LA. The attorney in West LA files a competing petition. Now it's me working with Kareem's wife, and this other guy's working with the son that he said is his son from Louisiana. And we're battling and battling and battling and battling, doing what's called discovery, sending interrogatories, which are the fancy word for questions. I'm asking for birth certificates, and then I'm have to hire an investigator. And incidentally, this happened to us. And we hired our investigator. Our investigator found out that the guy that said he was the son was not related to him at all. But it took up all that time for us to find out through the investigation. So that's why it's important. Again, you make your money through selling property, and probate to help you. But for you, your individuals, it's better to have a trust. Think about trust as private. Now, the exact opposite is with the trust. You have a trust, it remains private. The only thing that happens with the trust is once the person passes away, we file an affidavit of death of trustee. The property is transferred to the new trustee's name, and then it's distributed. It's as simple as that. Costs about $3,500 versus a probate. Probate probably costs you anywhere in excess up to $20,000 plus. And that's what your loved ones have to pay. That's not including the fees that you guys are going to make, which is great. So whether you sell it through a trust or through probate, you're still going to make your fees. But the person's family, they're going to pay an exorbitant amount of fees, legal fees. Yes.
I have a scenario. You let me know if at the end I can share with everyone and you can give us an idea.
Sure. You want to share it now?
Okay, yeah, that's okay with you guys. So pretty much I has sold a house to this young couple 3 years ago,
Mhm.
okay? He was 27 at the time. His father took money out of his house to give it so that he can buy a house. He was already married with this young lady, right? But he wanted to be the property only on him, by himself. The property was purchased under his own property.
In his own name.
Yeah, only
basically.
his name, but the way that title was held was only under his name only and not the wife. So the
Mhm.
wife was part of the title. And he unfortunately passed away like 2 months ago. And the father is telling me that if he can, because the property's on probate now, right?
Mhm.
Because he passed away. He's wondering if he can go back and try to, because he had cancer. He didn't pay like a few months, so they are kind of late on the mortgage. And he was wondering if he can pay up to date the mortgage and take it out of probate under him. Because obviously it was his son and he gave him the money for the house and not for the actual wife. Do you think that will be?
So the
possible?
son passed away,
Yeah.
not the dad.
No, the son.
The dad gave the son the money to buy the house,
Mhm.
and it's in the son's name.
Yes.
Okay, the
Although he
son.
was married, it was only under his name as his sole and main property.
But his son's name, not the dad's name.
Yeah,
Okay, so the son had no children.
no.
No spouse.
He just passed away. He was at 30. They didn't get to get pregnant.
Okay, and the son doesn't have a spouse.
He has a spouse, but like I'm telling you, even though when they purchased the property, he was already married, but the wife, but he didn't want the wife to be part of the.
Oh, got it. The son didn't want the wife to be part of it. I'm sorry, I was following. I was thinking you were saying the dad.
No,
The son.
Himself.
Yes,
So the way that he held title was his own property, like a
Got it.
married man, his own separate property, pretty much.
understand. How long ago did they have the property?
For 3 years when I sold them.
3 years when you sold it to him?
Yeah, I was in 22.
Okay, well, more than likely, it'll probably be something like this, that the wife will end, I'll just cut to the chase.
Yeah,
More
that's
than
what I
likely, the spouse is gonna get half, because what happens when you marry this community property, even though it's in your own separate name, okay, that helps when you're going through divorce. But when you die, if you're still married, it's gonna be community property. She's gonna get half of his estate, okay? 50-50.
Okay.
Now his separate property, because we're saying it's a separate property,
That's the only one.
no.
Oh,
Let me explain to you. That whole house
yes.
is community property. Boom, she gets half. All right. Now his half is his separate property, because that's hers,
Okay.
and this is his.
Yeah.
Bam, she gets half of his too. So about 75%,
So she will take 75%?
more than likely.
Okay. Because.
Those are just the rules, because again, now you're getting into, they're gonna
Okay.
input family law. I mean, it's gonna be a battle unless they can show that, the dad can show that he contributed somehow. But for the most part, when you're married, your time, energy, and skill belongs to the community. So if the community pays for something, if her and I are married, even if it's in my name, if I use my income to pay for that house, half belongs to her. If she used her income to pay for that house, half belongs to me. The law says your time, energy, and skill belongs to the community. So it belongs to both of you. Yes, sir.
What if you sign a prenup?
Well, if you sign a prenup, that's something different. But even though you sign a prenup, you will still have to keep all of your income and everything separate. And more than likely, most people don't do that. Again, the number one rule, your time, energy, and skill belongs to the community. You sign a prenup, but you'd have to make sure that you're not using community property to pay for that separate property. Community property is your income. Remember, your time, energy, and skill. All right, now let's get back to, I hope that answers your question. You can always talk to me afterwards.
Get your business card so that we can hire you for her. I don't know how they're gonna handle it, but the dad asked me, could you please ask, because I told him about the class, and I said, well, I'm not sure about that particular situation.
Mhm.
But we're having an attorney coming over.
Yeah.
So I will get your information and then we can get a hold of you.
No worries. Yeah, anytime. And Kareem will tell you, Norma will tell you, you guys can call me anytime. This is what I enjoy being a lawyer.
Oh.
All right. So now, again, a trust is the only thing that's private. Everything else is public. A will is public. and no will is public. The difference between a will and not having a will is it'll pass in testate, which we're talking about right now. If you have a will, it'll pass exactly how you want it, but you still have to go through probate, and you're still gonna have to pay, the client is still gonna have to pay all these exorbitant fees. And don't remember, I love probate. I make more money on probate than I do on wills and trusts, but I still advise people the right thing to do is to get a trust as far as you guys. And I touched on how long the process, 4 to 9 months, in some cases up to 12 months. But reality, it can be up to 3 years. 3 years. Just like Kareem found out he had a son in Louisiana.
No.
Something happens to Kareem, you're going to get all these calls. We have another that we're still working. It's almost going on 4 years. Now, this particular gentleman, we found out that he had possibly a few kids in other states.
Oh, wow.
And this is what people do. Lawyers pay for services, and they see these probates that come up. And again, we have to publish it. We have to pay a fee to publish it, put it in the newspaper. It has to be in the newspaper, was it 30 days? Something like that, 30 days ahead of time, the probate, to announce to the world that someone just passed away. And when that happens, lawyers get these sites and calls, and the next thing you know, they're trying to find out if this person is related to this person. They'll send you a letter. They'll say, hey, it looked like you may be ready to inherit some money. We need to know if you related to this person. And then they call. We found out a couple of them kind of fell off. They weren't related, but that's what happens when you probate. Probate, remember, is public. And again, as I said earlier, we've done it as fast as 2 months, but you still have to wait till the 6 months, 6 month period. Then how to start a probate. You file a petition. We got the name of the petition up at the DE 111. It's a petition. Petition is a fancy word for just saying you ask the court. You ask the court to open a probate because my loved one passed away. And since they passed away, I'm asking to be the administrator. And the administrator is the one that's going to be in charge. And you can have full authority, which we always try to get full authority, or you can have limited authority. And the difference is, I'm hoping not getting ahead of my slides, but the limited authority, you'd have to get different bids on the house, and the court would have to approve the sale. And that's what we don't want. In a lot of cases, in a lot of cases, the house needs to be sold because if they're in probate, they probably can't afford to keep the house. There's a saying in law that says probate is a poor man's will, because they couldn't afford to do a will when they're alive, or they couldn't afford to do a trust. So now it's going through probate. And usually their loved ones, the kids, they have to sell the property to pay all the court fees. We had one, it was a sad state of affairs, the brothers, the 3 brothers.
Yes.
And now 2 of them are homeless. But again, they had to sell the house quickly, and we had to do our job.
And how we first met is that the attorney that the one party was using, he wasn't even aware that we had a sale date for the foreclosure, because it was a pre-foreclosure. And we had got so far, the time had taken so long that we had a sale date coming up, and he wasn't aware of that. So speaking to attorney Emanuel Thomas, I just felt that he would assist and get us through that process, because they were that close to actually losing it to foreclosure.
Yeah, and that happens a lot in probate. So again, like I said, most people that have probate, they usually need to sell the property. A lot of times they have an idea that they want to keep the property because it's mom's house, it's dad's house, they grew up with it. But for the most part, they usually have to sell it because they can't afford it. So we usually have to act fast. And
And not to,
no, go ahead.
And working with Mr. Thomas, he was able to file some different documents with the courts to stop the trustee sale date. And we stopped it twice.
And that's something I want to share with you guys, because again, and not tooting his horn either, but I like working with him because he goes to the court. We just had a hearing, was it last week? Friday. And Kareem's behind was up there in downtown in the courtroom. And I was doing it online. Kareem was in the court.
We're just to show that Norma has already, we have escrow open, we have a receipt of the earnest money deposit, we have a fully executed purchase contract, we have a pre-qualification, just so that the court gives us full authority, because if you don't get full authority, it's a headache.
Yeah, and I want to share that with you guys, because that's something that you guys can do if you work with your attorneys in probate. We had a case together. I think it was in San Bernardino or Riverside, one of the two. And the court was not going to grant us authority that day. And he was there. And the judge asked, so who are you? He said, I'm the realtor. I just want to show you, Your Honor, that we have an executed contract. We have this, we have this, we have this. And the judge says, okay, Mr. Thompson, I'll go ahead and grant it then. Since you're already in it. So ever since that happened, that was a couple of years ago, I have his butt in court every time we're going to see the judge with paperwork showing. And it just goes through right away. Like I said, because this stuff can lag on and on and on and on. So what happens if you're not prepared? Say, for instance, what the court does, which is somewhat troubling, if there's something missing in a probate, the court would issue something called probate notes. And they'll say in the probate notes, you have to correct this within 3 days before the court hearing. But they usually put them up 3 days before the court hearing. So what's going to happen is when you get to court, they're going to say, okay, Mr. Thomas, we're going to give you a new date. What's our next court date? It'll be 60 days from now. So if you're trying to fight a foreclosure, you're in trouble. You got to contact the bank, which we have to on a regular basis, contact the bank, work out the bank, show them that we actually have something. We're in the process of selling the home. We have buyers. We have a fully executed contract. We're ready to go. And usually the bank will work with us. Usually they'll work with us and give us about another 60 to 90 days, depending. But one, we had to do that, what, 3 or 4 times, didn't we, Kareem?
That was our first. Why can't I think of her name?
I don't know, but it worked out. It worked out, but it just takes due diligence on everyone's part. Our part as attorneys and your part as real estate agents. And I tell you, the word gets out and people be knocking on your door. On the fee, usually about $465 unless your clients can get a fee waiver. Most of our clients get a fee waiver because, again, they're not in a position to keep the house. More than likely, that's probably why they're in probate. And I think I told you about the request in the publication. That's the first thing you have to do is announce to the world that you guys are in probate. And once you pay that fee, which is anywhere from $500 to $2,000, it could be upwards even more. We had one in Hawaii. We were selling the property. I think it was actually through Legacy as well. It was through Legacy. It was through here. Man, we do a lot with you guys. It was a Uramura case. And we had a probate with her husband. And unfortunately, the probate was about to be granted, and her husband died. It was almost like we had to start all over again because she wasn't related to his father. She was the wife. So we had to notify people in Hawaii, uncles in Hawaii, who were 80 and 90 years old, we couldn't get a hold of. So we had to pay over $2,000 to publish it in Hawaii. The judge allowed us to do that. He goes, well, I don't know, Mr. Thomas, you got to give notice. And I said, Your Honor, one uncle's 90-something years old. I'm not sure if he's alive. The other uncle's 80-something years old. I'm not sure if he's alive. I said, we reached out, and he said, well, I don't know what to tell you. Those are the rules. I said, would you allow me to do a publication over there? He goes, yes. And had no idea it was going to be that much money in Hawaii. But it was up there. And that comes out of our pocket first. One good thing about probate, when you can tell your clients as well, it comes out of our pockets first. We get paid and reimbursed for all those things at the end. So the publication, we pay it. The probate referees, we pay it. At the end of the day, I'll call Norma and say, here it is, here are all these things. And everything has to go through the court. So it's fair. So if it's 2 loved ones that are surviving, the court has to write it off and say, okay, yes, Mr. Thomas, you can take your statutory fees, which means my legal fees are determined by the court. And you can pay loved one A and loved one B 50%. That's what you can do. And once that's done, then we can cut the check. So everything is done fairly. There's checks and balances for everyone. All right, and what else here? Oh, talk about the creditor's claim. Also, too, as attorneys, and you guys can help us with this as well, we have to make a reasonable effort to find creditors. So if the decedent owes credit card bills, owes light bills, owes taxes, or anything like that, we have to make a reasonable effort to notify them that the decedent passed away. First, the publication. If they don't catch it on the publication, then we have to make reasonable efforts to say, hey, Discover card, Johnny Smith has passed away. Does he owe any debt to you? And they'll do what's called a creditor's claim. They have a certain amount of time to do a creditor's claim or else it's waived. And once they put that creditor's claim in, again, the court, the probate referee will look at that and contact me and says, Mr. Thomas, before we close this, did you pay Discover? I'll say, Your Honor, we settled for $3,000 instead of $4,000. He says, okay, well, I need the creditor to sign off on it saying that's exactly what you did. And once that's done, then it'll be granted. So everyone gets paid. So we can't even escape bills of death.
I have a question about Medicaid.
Yes.
Can you let me know about what Medicaid, if they were on Medicaid, what do they have to pay and how does that work?
Usually
On the house and they were on Medicaid.
Usually they want to get paid as well. One thing about our government, they're going to be, let me tell you about how creditors come. You guys may already know this, but creditors come in and liens come in these forms. You have lawyers' liens come first. The reason being is because lawmakers, they're all lawyers. So sometimes it's good to be a lawyer. It comes first. Right after that, the government wants to get paid. You're going to pay the government, then other creditors. So to answer your question, yes, they're going to want to, and we'll talk more about detail after, but yes, they're going to want to get paid. So is that what you're asking me? Or I'm not sure what you're asking.
Because when people are on Medicaid, I've heard that a lot of people have lost, I mean, they come out with nothing but errors because the person owes so much money to Medicaid, not Medicare, but Medicaid.
Mm-hmm.
And they thought that was just a free service that California gives, but they found out, no, it's not.
Mm-mm.
So that's why I wanted to know what.
Yes. What you can do, it depends on what the estate is worth. But yes, they're wanting to government, they're going to get paid. And it's the law. Even give you an example, even in personal injury cases, by law, I have to notify Medicare, Medicaid, and Medi-Cal that this person's in an accident. And do you have any liens? Did you pay for anything? And if they say yes, they're going to send a letter to the insurance company before they pay Mr. Thomas. We need to get paid. That's how it goes with Medicaid. So to answer your question, one thing we can do is if there's nothing in the estate or if the estate is minimal, we can negotiate. So say, for instance, if the house had a reverse mortgage, we deal with those on a regular basis, and the only thing left in the house was $50,000. Well, I'm going to contact them and say, okay, what's left in the house is $50,000. There's attorney's fees of $20,000. There's court fees of this. This was their portion. And then they'll usually come after just their portion. And here's how we can kind of skirt tail around that. As administrator of the estate, you're allowed to get the same fees that I'm allowed to get. So say, for instance, if I get $20,000, then being the administrator of the trust, you're going to get $20,000 too. But if there's multiple beneficiaries, they'll have to agree to it, but it is statutory. Right, so they can object to it, but if they don't object, it's statutory as well. Does that answer somewhat of your question? If you have any further, you definitely just feel free to call me. And most people don't know that, but the administrator of the trust can get paid as well. Their fees are going to be the same as mine.
Just to clarify on that question, so whether it's in a trust or it goes to probate, if, let's say a senior citizen is on Medicare and they pass away, it still gets distributed to the government.
Well, yes, because what's going to happen is by law, you're going to have to notify them. Yeah. So yeah, we can't get around that.
Can I add something to that?
Go ahead.
There was a new law that came out, I believe, this year, and it's gonna be after a certain age. So I can look that up and send it to Norma.
Yeah.
I could distribute it to you guys.
Or feel free. Lucetto's information is going to be here. Like I said, this is my right hand right here. I couldn't do any of this stuff without her. She was the biggest blessing from my law firm. I got her from paralegal school. And then I had a conversation with her. I said, Lucetto, I said, how would you like to stay? She goes, yeah. Yeah, but she's my right hand. Yeah, but feel free to reach out to her. Reaching out to her, if she can answer, she'll answer it. If she can't, she'll call me and I'll get right back to you. Now, talking about probate or not to probate. What actually do you probate? What actually don't you probate? All your assets can be probated. but you can prevent probation. Probation. I see I do criminal law too. I give talks in criminal defense through my apologies. But anyway, you can prevent probate if you put down a beneficiary. If you have a bank account, you put down my beneficiary is going to be Kareem. Okay. Then what happens when you pass away, has to wait the 45 days and then go to the bank, said I'm the beneficiary, show some ID, show a death certificate, and then they're his. If you don't do that, then that goes through probate. All your personal items, cars, furniture, things like that, it should be added in probate. But keep in mind, those are going to be shown at a discounted amount. If the person, say for instance, you have two people bickering and all the furnishing goes to both. Well, one person wants to buy out the other. Where they're going to buy out the other one, not at the value that you think it would be. It'll be almost at like garage sale value. But anything that you can leave to put a beneficiary on is better to do it that way versus going through probate, because it's gonna add up the cost. Say for instance, the house is worth $400,000. Then you got a bank account worth $250,000. Well, now the assets are worth $650,000, and they're gonna ask you to get a bond. And does everyone here know what a bond is? A bond is, in other words, I know they know what I'm talking about. A bond is just a fancy word for insurance. If I pass away and Lucero is the administrator of my estate and my estate is worth $1 million, well, the court's going to say, well, Miss Milena, we need you to get a bond for $1 million. The more expensive the estate, the more expensive that bond is. So that bond may be about $5,000 that she's paid. And what that's to ensure that she doesn't take the money, because she's going to have full authority, sell the house, take the money and run to Vegas. That way, the other beneficiaries are covered, or the other heirs are covered. And then the bond company will come after her. That's all it is. A bond is insurance. And 99% of the time, the court is going to require a bond if you want full authority. And again, that's something that the attorneys usually pay, and the bond company usually waits. But here's the thing. It benefits us if we do it fast, because that bond is required to be renewed every year. If it takes 3 years, I got to pay $2,000 every year. If I take 6 months, I only got to pay it one time. Now, joint tenancies in real estate. Now I'm speaking to the choir. I'm preaching to the choir now. Joint tenancies and tenancies in common. You guys all know what that is, right? Okay, you too, right? All right. I knew you did. All right. So a joint tenancy, if the person dies, it goes directly to the other person. You have to file a death of joint tenant. If it's a tenants in common, then their portion has to go through probate. Again, that's the same thing we went through when I was telling you had to file a publication in Hawaii with you guys. Same thing happened. They only own 25%, so we had to do the entire probate, but only she got that 25. Only 25% was probated, because the other 75% belonged to someone else. And what else here? Personal property, bank accounts, vehicles, all those things has to be listed in the probate. And that determines the value of the estate. And the more value of the estate, the higher the bond, the more money they're gonna have to pay. Bonds required. So you already talked about the bonds. And then once you are approved, granted, something called issues are called letters. And letters are what you take to banks. Letters are required by Norma. Norma says, do you have the letters? And I say, yes, just send me a certified copy of the letters. That just says that you guys are now the administrator. The court said you have full authority and you can sell the property, do whatever you need to do, but you always have to act in the best interests of all the beneficiaries. It's called a fiduciary duty, which you guys have the same thing, a fiduciary duty. And that's what the letters are. And the EIN number. Does anyone know what an EIN number? Okay, good. Yeah, you cheating over there. No. Now that's the best way to put it is a replaceable of a social security number that was still attaches to the person's estate. So when this person passes away, instead of using his social security number, we get an EIN number. And then the administrator can open a bank account in that person's name with an EIN number instead of a social security number. And then those funds, After they distribute, they go to that person, and that person can write checks to everyone under that EIN number. And also for tax purposes, the government wants to know about this estate, how much the estate was worth, and the government always wants to get their share. They call it their fair share, but that's remain to be seen. And then the notices. Notices have to go out to all the beneficiaries. They don't have to go to court, but they have to be notified. At the beginning, we had cases where everything was looking good, it was looking great. We dotted all our I's and crossed all our T's. It was great. And the judge said, Mr. Thomas, did you give notice to the beneficiaries? I was like, oh, shoot. Okay, we'll see you in about 3 months. Make sure you give them notice at least 30 days ahead of time. So everyone has to be notified. There's no secrets in probate. Again, probate is public. And then the final steps, you got to distribute within 1 year the letters are issued. In other words, you have to pay out. And if you don't, the court will set an OSC at the minute you are granted to be the administrator. And OSC is short for order to show cause. Order to show cause usually means order to show cause why I should not deny this probate, cancel this probate, or sanction you, the lawyer, for $1,500 for not doing this within the time frame. And usually what happens is, if the OSC comes and goes, the judge will allow us to explain why it didn't close in 1 year. Usually maybe because we couldn't find a heir, we couldn't find another beneficiary or something we were going to maybe fight it or something. And usually judges are pretty good about giving us extending the OSC. But they immediately put up an OSC. And that's in all cases where there is probate, criminal, civil, there's always an OSC because the courts want these cases to close. And then last, well, almost second to last, is discharge for personal liability. You want to talk about that, Ms. Milena? I don't want to just stand up here. I want to let her talk. Go ahead, explain personal discharge from personal liability.
So basically, once you're done with the whole probate, you do have to make sure you notify the court, or else you're going to have to keep paying the bond. You're going to still be liable if anything happens. So you always want to make sure you do that like at the end, so you're not held liable.
Well said. So in other words, what happens is I'll send out a letter to all of the beneficiaries, everyone who's got a check. They have to sign saying, I received my 1/3. And then once they receive their 1/3, I file that with the court. And then the court says, okay, great. Then I file what's called an ex parte. Ex parte means just one side is filing something, because usually the court wants two sides filing something. There's usually a petitioner and a respondent, or a petitioner and a defendant. Ex parte just means one side is filing something. So I'll file something saying, hey, Your Honor, I've distributed everything. I paid all the creditors. Now I want to be discharged from this. And then once that happens, I'll notify the bond company, and the bond company will stop sending me a bill. And then everybody's done. All right, here's some key points. Probate cases can take up to 12 months. Scratch that. They can take up to 3 years. 2, it says $5,500 to $8,000 will be spent in statutory predetermined fees. That's old. The price of houses now, what, 400,000? What's the average price of houses? That's you guys' field. $800,000? Yeah. So you'd be looking at statutory fees probably in excess of over $20,000. 3, you will pay attorney fees, but attorney fees in probate are statutory fees. So statutory fees are attorney fees. So there's no, in other cases, if you hire me, I'll tell you my fee is $10,000 or $3,000 or 30%. In probate, it's determined by the probate code. It says it. The first $100,000 you get 4%. The second $100,000 you get 3%. The third $100,000 up to $1 million you get 2%. So it's already written in the books. I can't charge you any less or any more. That's exactly what it is, unless I do something extraordinary, something out of the ordinary. Then I can charge you more. But that's the probate fees. So it's not attorney fees, it's the statutory fees. And along with that, you got the publication, you got the probate referee. Now the probate referee, his job or her job is to appraise the property of what the property was worth at the time of the death. And in some cases, the person may have died 3 years ago, but the family member said, oh, I always want to just keep it. I don't want to change it. I know I had to. And then you have to explain to the judge, why did it take 3 years? And again, sometimes the property is worth $100,000 at the time of death, but now it's worth $1 million. I'm over exaggerating it, but that's what happens sometimes. So, and then the judge looks at you probated at the value at the time of death. If you do not have a will or trust, if you do not have a trust, or if you have a will or no will, you have to go through probate. And 5, and finally 6, if someone contests the validity of the trust, you have to go through probate. So that means, remember, trust is private. And usually in the trust, they'll say, if you contest this trust, you're only going to get $1. That's just common. It usually doesn't work in courts anymore. Everyone puts that. We still put that. But if I can show that it was undue influence, I can show that you convinced my mother to sign this trust because you were her caretaker, I'm going to say it's undue influence. Because you didn't allow us to see her, that's undue influence. Or you threatened her, that's undue influence. Or she really couldn't understand it because she had some type of disease, Alzheimer's, or either dementia, then we're contesting the trust. And once the trust is contested, then it goes through probate. At the end of the day, the judge will determine the validity of the trust. And if the court feels that it's valid, then the estate will be distributed according to the trust. But those are the avenues of going to trust. And so, any questions? I'm done now.
I have a question.
Go ahead.
Of course. What is the best way to hold title? Because some people hold it right as survivorship, right, when it comes to a trust. What are yours? What do you think? What's your opinion on holding title?
You mean are you referring to?
When you're doing the grant deed and you're holding title and you're putting it on the grant deed and then you're putting it on like joint tenant, right of survivorship.
And that depends on if it's a business partner or if it's your spouse.
And it's a spouse. Say that's what a lot of us.
Yeah, joint tenants with right of survivorship, or that'd be the best way. Because again, that speaks once the person dies. Once the person dies, the only thing you need to do is just file a death of joint tenant, and then it goes directly to that person. Is that what you're asking me? Or because you mentioned trust too.
I know there's all those different ways to hold title, and I know some attorneys have it differently, that it's not joint tenant, it's the other one, tenants in common with the right.
Yeah, no, tenants. Well, tenants in common, that would be, say, for instance, if Kareem and I are partners, and then I want to make sure that my half of the property when I die goes to my estate, and he wants to make sure that his half of his property, when he passes away, goes to his estate. That way, when either one of us die, that property still belongs to my family.
But nowadays, we're dealing with blended families. And,
Yeah.
So maybe that person wants their kids to get half of the house and the other spouse wants half of the house. So and then you have a living trust. So I just wanted some clarification on living title, because that wouldn't work for joint tenants if you have a blended family.
Well, if you have a blended family, that's when the trust comes into play. Because do everyone understand how a trust works? Just want to make sure. All right, well, tell me. I see you shaking your head. You've been quiet all day.
Oh, I just got here.
No, I'm teasing. You want to explain it, or you want me to go ahead?
Go ahead.
Okay.
You're the expert.
No. Lucetto's the expert. Okay. Now, what a trust does, once you open up a trust, you have to fund the trust. And when you fund the trust, you put the house in the trust. So say, for instance, if I put my house in the trust, what's going to happen is I'm going to make a deal with myself. It's kind of crazy. I'm making a deal with myself. I'm saying I'm the trustor and I'm the trustee. I'm trusting myself to be good to me. So it's going to say Emanuel Thomas, as trustor, owner of this property, is granting Emanuel Thomas, the trustee, his property. So I'm going to record this deed in Norwalk. Not sure where it is out here, but in Norwalk. And that property is no longer going to belong to me. It's going to belong to me as trustee. And then within my trust, I can say how it's divided. I can say my wife's brother gets 1/3 of the house. She'll sign off on it. And my kids will get 2/3 of the house. We'll both sign off on it. That's how you deal with a blended family. So we have a blended family. So that's how we do. We already discussed that, okay? Your brother's getting nothing. No, I'm teasing. No. But did I answer your question? But to deal with that, that would be the trust. Go ahead.
Since you're here, the way I tell my clients, now that you're here, tell me if this is accurate or not.
Go ahead.
Right? What I tell them is, a trust is when you surrender your distributorship rights to an entity, which is a trust.
Mhm.
That's how I explain to them, just to keep it simple to them.
Yeah.
Is that accurate, incorrect? Is it saying more, less? What is it?
Kind of, because you don't totally surrender it. You surrender for a time because there's two things. There's a revocable trust. That's what most people get. 99% of the time, revocable. Meaning, if I decide to wake up one day and I don't trust myself anymore, I can revoke that trust. I revoke it. Then it goes back to the way it was. So it's a revocable trust. Now, an irrevocable trust, I'm getting more and more calls from people that want an irrevocable trust. You have to be careful about, counseling on that because once they try to get something out of the trust, well, it's irrevocable. You can't. But with a revocable trust, you still have control. That's why you can't hide it through tax things because you still have access to it. You can revoke it at any time. In fact, you're still the person in charge. You want to borrow against it. In fact, the revocable trust says that you want to borrow against, you can borrow against, you can sell it. You want to sell it, whatever you could do as owner, you can do it as trustee. And usually you are the trustee. So if you're married, it'll be the revocable trust of you and your wife. And you guys can do whatever you want to do. You guys are making an agreement with yourself to manage this trust to the best of your ability for you too.
But the irrevocable trust, isn't that more like an exotic product, as they call it? Because it's usually like for corporations, something where there is no change. That is like trust fund babies, right?
Yeah.
Nothing's touched, nothing moved. That's what they get regardless. You can challenge it,
Yep.
protect it from, right? So
That's
that's why I usually just tell my clients the irrevocable trust part, right? That they're just pretty much surrendering their right for a moment until they pass away, whatever.
or until they just decide, until they change their mind.
Right.
But you're right in the irrevocable one because that's what I'm getting phone calls from politicians.
Oh, okay.
A friend of mine's running for mayor. She wants her irrevocable trust because she wants to make sure that her constituents don't know that she has property, and I don't know why. But anyway, they want it irrevocable. But revocable trust, remember, you can always revoke it. That's why it's a revocable trust. And you're basically trusting someone as the trustor, the trustee, to manage your trust property to the best of their ability for your benefit. And it's usually you. And then you have successor trustees, which are usually the kids or another loved one. And it's their duty to manage your trust property for your best interest as well. And it's fiduciary duty. If they don't, they mismanage it, then they can be held liable. Yes, sir.
On a revocable trust, can it only be revoked by the person creating the trust?
It depends on how it's written. It depends how it's written. So basically, usually that's the case. So say for instance, I write it up and I say that this is a revocable trust. My successor trustee, say for instance, is Lucetto, my daughter. Then I put in there that she has all the same rights that I have. And I can put on there that she can revoke this trust if it's an agreement between her and her brother. Then they can revoke the trust. It all depends on how you write it. So to answer your question, generally, it's usually only the person that wrote it. And it usually states that once this person dies who wrote it, it becomes irrevocable. But to answer your question, 99% of the time, that's it. But every now and then, someone will write it up just a little bit differently, say it's going to take two people to decide. We have to fight cases like that too. Any other questions? I know you got a question. I see it burning, but I'm going to go to her first.
How legal is, I hear a lot outside
Uh-huh.
that they are doing the trust, it's like living trust. I can do living trust. And somebody invited me to a meeting that I can learn to do living trust. I say, no, I don't want to deal with that. How legal is that?
How legal is what?
For a non-attorney to,
And, like people who's not a lawyer for that, so
Uh-huh.
doing not trust.
Well, it's legal. I mean, they even got legal Zoom. But here's the thing. If you do a trust and you mess up, you'll be treated just like an attorney and held liable. So in other words, if you mess up on a trust and you do it for Johnny and his daughter, and his daughter found out that, hey, you didn't close the gap or something, and the property gets stolen, or something happened with the property of the deed because you didn't make an irrevocable trust after he died. Just give you an example. Well, you're going to be liable to buy her a new house, just like I would. So, and the laws change on a regular basis. But to answer your question, if
Anyone can do it, but.
yeah, you don't have to be a lawyer to do a trust, but you have to be a lawyer to sign off on it. Yes.
What happens if the executor or administrator is not performing the best for the beneficiaries and there's some shenanigans going on? What's the recourse?
That happens all the time. We're in court constantly for that, is to get them out of the trust. So we'll file a motion in the courts, letting the judge know that we need to have this trustee removed and put in a new trustee. That's why usually a trust has a successor trustee. You have about 2 or 3. So it has myself as the trustee, then it has Lucetta successor trustee, then it has her as successor trustee if she can't do it. Usually has about 2 or 3 levels. And so if something happens where I'm not performing properly, they can file a lawsuit against me and say, we need to have Emanuel removed. And then usually what will happen is the court will say, okay, well, while going through litigation, Ms. Thomas, we're going to remove you. We're going to make her temporary trustee while we're going through litigation. And then if I object, say, hey, Your Honor, they're the ones trying to get me out. Why don't we have a bank do it? And or the court can assign a temporary trustee while they're trying to figure this out. And if they found out that I have been doing things badly or wrong or intentionally, not only will I be removed, but I'll be liable for whatever money they lost. So if the trust could have made $100,000 and instead I lost $150,000, well, not only am I going to be removed, but I'm going to be liable to pay these two $150,000. Any other questions? Yes.
If I want to do my living trust and I have stay in the other country, so can I put in the living trust over here?
Yeah, it's like this. This is how California has jurisdiction over the person or the thing. So in other words, if you're a resident here, or you say you live over there, if your property's here, you can form the
if
trust.
I'm here
Yeah.
and I have properties in Mexico or whatever, another country, so can I put in my trust?
No. The reason why I'm telling you that is you can, and you're hoping that everyone will abide by it. But here's the problem. California can't force anyone in another country to do something. So say, for instance, if your property's in Spain, well, California can't go over to the Spanish government and say, hey, you know what, she had a trust here, give me that property. We can't force do that. But here's what's a little different about California. If anything is legal in another country or another state, California will recognize it. So say, for instance, you live in Spain, but the properties in California, that's a bad example. Say, for instance, you got married in Spain and you come to California. Even though you didn't get married in California, California said if the marriage was valid in Spain, then we recognize it as a valid marriage. So any law that's valid in that particular country or that other state, California recognizes it. And here's the ticker. If it's not valid in that country or state, then we have an argument. We've been through those two. We have an argument saying, hey, this is what needed to happen in Spain. It didn't happen in Spain. Therefore, it's invalid in Spain. It's invalid here in California. And we usually win those two. But does that answer your question? We can't reach out to other countries and force them to do something. But as Californians, we'll say if it's valid in another state or another country, we'll accept it as being valid here. All right. Any other questions? Go ahead, brother.
On fees, so partitioner, are those the same fees that the attorney charges? Does it have the same scale of the first 100,000, 4%?
Oh, you're talking about the petitioner?
Yeah, the partitioner.
The petitioner.
The referee.
Oh, the referee.
Yeah, the referee is partitioner too, right? Isn't partitioner?
No. No, partitioner is different. But anyway, the administrator. I think that's what you mean. Are you asking about the administrator?
The court-appointed partitioner, the one that
the court-appointed referee.
Yes, correct.
No, the referee's really cheap. So basically, the referee usually charges. We have one charge $160. I think the most like $700 or something for a referee.
That's the appraiser. We would know
Yeah.
that's an appraiser.
That's basically what he's an appraiser, but they call him a probate referee. I don't know why they give him that name, but that's all it is, an appraiser. He's gonna appraise the property, what the value was at the time of death. That's it.
I'm dealing with a case right now where the person passed away. We left the trust to 3 parties. They're all fighting.
Now you gotta go through probate.
So I'm dealing right now with a court-appointed partitioner. Not partitioner, that's his official legal title. He's a partitioner.
Okay.
He's the one that is basically the ad hoc owner of the property, and he's making all the calls appointed by the court. How the property is going to be sold, what's going to be appraised at, and what the charges are going to be.
Okay, I hear what you're saying. That's an extreme. That usually does not happen. So in other words, what happens is the court will appoint someone.
Look at me, huh?
Yeah. I mean, that's rare. What happens, this happens in divorces and everything. So if you and I, the court says you and I are supposed to act in good faith.
Correct.
Even though we're battling. If I ask you for some information, you're supposed to give it to me. If you ask me for information, you're supposed to give it to me. That's called discovery. You say, answer these questions, Mr. Thomas. And I say, screw you, I ain't answering these questions. And I say, you answer these questions for me. You say, screw you. Or I say, give me these types of documents, or vice versa. And you're not giving them to me. We'll both complain to the court, say he's not playing fairly. He's not abiding by the rules of discovery. He's not this. Then the court will appoint someone. And that's a little bit differently.
Okay.
That's a little bit different. But yeah, these fees are not going to be the same thing as tax fees are not going to be the same as statutory fees. What he'll get paid hourly. So what he'll say.
Okay, that's what I wanted to know. Because he is driving his feet on everything. Yeah, if there was a certain cap, I'm sure he's like, you know what? I'm getting paid this much, move on. But I'm into a different tangent here.
No, good. But what happened in cases like that, they'll ask for certain hours. So their fees may be $150 an hour. They're usually around 150, depending on their level of skill, 150, maybe 200. They'll say, Your Honor, I've already done, 10 hours. I'm going to need at least 10 more hours. And just, okay, I'll grant you 10 more hours. That's how they usually work.
Okay. You answered confirmed every doubt I had on this. I got it.
Yeah. So usually at worst case scenario, it's usually about $5,000 that they'll accumulate. From 3,000 to 5,000. Really?
Oh,
a lot of hours.
Way beyond that.
Yeah. Yeah. But it's hours.
Yeah. Okay.
Yeah. All right. Who else? Go ahead.
Do you do the living trust?
I do.
How much?
Well, ours is
For
$3,500.
one property?
One property, $3,500. You talk to her. She's the one that does it. She does everything. I just go to court. Yes.
So when someone passes away, in general, it's like there's a sense of urgency because I think what happens is most people just are in shock and they let time pass by. But if they have a mortgage, then there's a sense of urgency because it's like they're gonna be potentially foreclosed on, right? Unless somebody else can inherit that loan and buy them out. I'm gonna assume at market value.
Yep.
And then there's also like a race between the probate it's like a race between the courts is what I'm hearing.
Yeah.
And the foreclosure process.
Yes.
Okay.
Yeah. And one of the things we tell our clients too, which this part's not legal advice, but we tell us, look, your mother passed away and they want to keep the property, but the interest rate was really, really low on the mortgage, with their moms. And they know they can't qualify for it. I said, well, look, here's the deal. I said, you're supposed to go through probate. I said, but usually the lenders won't bother or check if you keep paying it on time. Keep paying on time, you don't no harm, no foul. And sure enough, we had the property in South LA, friends of mine. They kept missing payments, and sure enough, lender found out they're in foreclosure. So.
What if they just continue to pay?
Well, if they continue to pay, they'll keep paying until they pay it off. Then they have to deal with that deed if they pay it off later. We had a situation where she had it for years. Her grandmother died, her mother died, her uncle died, and then it was her. And she did, I don't know if she did it intentionally or not did it intentionally, but she tried to get it switched over to her after her parents died by using some type of notary saying that the grandma signed it over and she was already dead. So now we're doing litigation in that. And the judge ruled that it's going to go to the kids and not to her. So, but yeah. Did I answer your question? Okay. Any other questions? You good? All right, well, thank you guys for having us. If you have any questions, feel free to reach out to myself or Lucetto, and we'll be happy to help you. And in fact, any question you have on law, just feel free to call us. We've been working with you guys.
You get that slide presentation?
Yeah.
Just- No, go ahead, take your time. Oh, that was it? Okay.
Yeah, no, that was it. That was it.
Eric called.